Bismillahirrahmanirrahim. And this is the second lecture on the topic of medical examination versus medical legal examination. We have to differentiate between what is medical examination and how it is different from the medical legal examination. The medical examination and medical legal examination both are conducted by the doctors. So, the authority, the scope, the procedure, the equipment, and the authorization to the doctors, they are different. So that's why we have to understand it, that what is the difference between medical and the medical legal examination. Although apparently in both the doctor is applying the principles of practice of medicine, but in both the objectives are different, and apparently it look like alike, it looks same, but there are many differences in the examination, so we have to understand that. We'll discuss the differentiate basically in both the examination. For example, regarding the purpose. In the medical examination, we apply all the principles of practice of medicine, but our objective is to diagnose and to treat the patient. Whereas in medical legal examination, the person who is authorized to conduct that medical legal examination is looking for the facts. He collects the facts, and that is the evidence. And this evidence has to be presented in the court of law. For example, a person is injured, he will note down what type of injuries, then he will draw a conclusion what will be the mechanism of these injuries, how they have been inflicted. So, this is the fact which he gathers during the course of his medical legal examination. So, the purpose in both is different. In medical examination, we apply the knowledge to diagnose and the treat, wherein in medical legal examination, we try to collect the facts, the evidences which have been inflicted on that person. Then the focus of medical examination is solely concerned with the patient care and well-being, because we are going to treat him and we want that he should be well after the treatment. Whereas in medical legal examination, there are legal implications and there are certain forensic findings. That means the findings which have a legal implication and they have to be presented in the court of law. And whenever they call you, you present those findings in front of the court so that they can arrive at a decision that they were suicidal, homicidal, accidental, who have inflicted them, what is the mechanism, and if the punishment has to be awarded, the amount of damage will be found out by the doctor and he will present it. Then, who will be conducting in medical examination? Any doctor sitting in private capacity or official capacity, in outdoor, in inpatient, in private clinic, the, the person can approach to any doctor for his treatment and examination. Whereas in medical legal examination, it is only and only conducted by authorized medical officers. Authorized mean they have been designated by the government and they examine the patient if they are living in the accident emergency. They are called CMO, casualty medical officer, whereas in dead, if the autopsy has been to be conducted, they are by the medical officers who conduct the autopsy. Then, regarding the place of examination, The place of examination in medical examination can be any health facility, any outpatient, inpatient, and office, and the general practitioner clinic. So, the place of examination is the health facility. And in medical legal examination, there are authorized places that the injured or the person who seeks medical legal examination cannot go to place of his like. He will approach to the nearest facility where the incidence has occurred, to nearest facility that may be a rural health center, tehsil headquarter hospital, district headquarter hospital, or teaching hospital. So the authorized place for medical legal examination is designated by the government. Then authority for examination. Who gives authority to the doctors to conduct the examination? In medical examination, patient himself, when comes, he gives the consent for the examination. Of, or if it is a minor, that is a child, the next of kin, the parents, they will give you the authority, they will request you the examination. Wherever in medical legal examination, patient himself will give if he is injured or in accident or he lands in the emergency, then it may be on police request. Police may request the examination, and similarly, this may be on the court order. So the authority in both examination for the conduction of the examination is different. Now, regarding the consent, in medical examination, patient himself or next of kin will give the consent, because the consent is the most important step in examination. If the patient does not give consent, you cannot force. Whereas in medical legal examination, it is mandatory. You have to take the written consent from the person, and sometimes the situation is such that if the person if does not give consent, the situation overrides and the consent can is not needed. Police asks you for the examination like the autopsy or the crime investigation. Then, for example, when we talk about the examination of clothes in medical examination, we do not, we are not concerned with the clothes. That may be for the social status and the personal hygiene and other purposes, but they are not important in medical examination. Whereas in medical legal examination, they are very important because the clause gives you the information regarding the identity, regarding the crime. There may be tears, there may be stains, broken buttons, or any information regarding the assault. There may be stains of the biological fluids, semen, stool. So, the close examination in medical legal examination is very important and necessary. Then the documentation in medical examination, they are basically the prescriptions, the clinical notes, the hospital charts, the investigation, the reports. Whereas in medical legal examination, it is the certification, or like in living, it is the medical legal certificate of the injured, and if it is dead, then they are the autopsy reports. Then the use of finding. In medical examination, it when we examine the patient, it find out the outcome of the patient, that how much the disease has progressed and what will be the outcome after the treatment. Whereas in medical legal examination, all the findings, all the facts which the doctor has gathered during the course of his examination, they are to be presented in the court of law. Regarding the scope of examination, in medical examination, it is purely concerned with the health assessment, diagnosis, and treatment. Whereas in medical legal examination, the scope has got legal implications and it solves the specific legal and forensic question which is asked from the doctor, that examine the person, find out the trauma or the injuries, find out that whether the uh, assault has been executed, poisoning. So that may be a legal aspect, and the scope may be to find out those legal implications. Then, when we talk about the documentation, confidentiality. The confidentiality in medical examination, it is between the doctor and the patient, whereas in medical legal examination, the information to the police and to the law enforcement and the courts. So this is the confidentiality in both the cases is different. For example, if we discuss certain examples in physical examination, when we examine in medical examination, we perform the physical examination. We take the samples for the investigation, then the lab results. Whereas in medical legal examination, this may be related to the age certification to find out the age of the person, or the medical legal certificate if the person is injured, if the person is poisoned, then if the person is dead, then we have to find out the cause of death, since how long it is dead, and sometimes the identity is most important question. So the objective is different in both the cases. Regarding the record maintenance, the record in medical examination is purely for the audit purpose or for the research purpose, whereas in medical legal examination, it is to be kept in safe custody and is to be presented in the court of law. Regarding the preservation of evidence, it is not required in medical examination, whereas in medical legal examination, you have to collect the evidence, preserve it, and dispatch it to the concerned lab. For example, if you suspect that poisoning has occurred, you will collect the sample, preserve them, and send to the chemical examiner. And if you suspect the sexual assault, you will collect the samples of the vaginal swab, preserve them, and send to the chemical examiner. So the samples are collected, preserved, and sent to the respective labs for the investigation. Then the examination facility, it may be at any clinic, private or the government capacity, whereas in medical legal examination, they are the authorized health facilities like the Tehsil headquarter, district headquarter, I have told you already. Regarding the timing, there are fixed timing for the medical examination, for example, hospital timing, the clinic timings, and they are displayed and the patient contact during those timings. But for medical legal examination, there is no time limit, and incidents occur at any time will be reported immediately to the nearest health facility, and they are bound to perform the examination at that time. Now, if we talk about the examination tools, what tools are necessary in both the procedures? In medical examination, the routine medical examination will require the stethoscope, the BP apparatus, the measuring tape, the torch, the hammer. So these are routine medical examination tools. Whereas in medical legal examination, beside these tools, because you are examining the person and you will be requiring the special tools, that may be a hand lens, a probe, a measuring ruler, and if in autopsy you have to it is to be done by the dissecting tools. So the tools of the both the examinations, they are different. Then what will be the outcome in both the examination? In medical examination, the purpose is, the outcome is the diagnose and to treat. Whereas in medical examination, the doctor gives an expert opinion. It not only examine the injury, that how its site, size, shape, depth, but it also give opinion. What is the confliction? What is the cause of this injury? How this injury has been conflicted? The weapon was blunt or sharp edge or firearm. Then that is the important job, and this uh, will be prepared in a case report form in the report, and that report is to be presented in the court for as an evidence. The court evidence in medical examination, it is rare, it is not necessary until unless there is some element of negligence or the some element which become the conflict between the doctor and the patient, then that may become in the court of law. Whereas in medical legal examination, the court evidence is mandatory, because being doctor, we have to put all the facts in front of the court, and as an expert and technical evidence, we have to draw the opinion, which is the final outcome, and the court will decide the case upon your technical evidence. Then, if there is failure to perform duty, for example, in medical examination, it will tantamount to civil or the criminal negligence, and there are the punishment for those. Whereas in medical legal examination, you cannot refuse, you cannot refer, you cannot postpone, because it is only that health facility where the authorized medical officer is there, that will is going to perform that duty, and if he does not perform, then there is a disciplinary action against it. Regarding the ethical consideration, the most important job in the medical examination is basically the patient care and treatment, which is the main focus. Whereas in medical legal examination, the collection of the evidence, the finding the facts, to record those findings, and then they are preserved to be presented in court of law, and you be impartial, you should remain focused to the facts, and those evidence they have to be presented in the court. So in conclusion, the medical examination is mainly concerned with the care and the treatment of the patient, whereas the medical legal examination, the main concern is the collection of the facts of the case and to present them in front of the law enforcement and the courts to arrive at a decision, at a conclusion, and that is the essence where the justice is delivered to the victim, and the culprit will be awarded the punishment, and that is upon your technical evidence. So thank you very much. This is all about the differences between medical and medical legal examination.